In this video, I'd like to discuss some of the issues associated for healthcare decisions when one is incapacitated. The basic documents we'll be talking about are the durable power of attorney for healthcare, the living will, and a designation of designee for disposition. And then there are some other docs that we'll be wanting to just touch on briefly. Those include a medical directive, the do not resuscitate order, the out-of-hospital DNR, and the Iowa physician orders for scope of treatment. Probably the most important document is the durable power of attorney for healthcare. And this form was revised in 2014 to address some of the concerns that primarily the physicians had with respect to potential liability for their decisions about an individual's mental status. The situation where it applies is this, that I am alive, but due to an accident or some other condition, I'm not able to make decisions for myself. It allows me to appoint an agent and even an alternate agent. And in the physician's judgment, when I am not able to make decisions for my own care, then the agent is given broad authority to make healthcare decisions on my behalf. These may include placement decisions, second opinions, or even treatment options. And if I want to specify specific instructions for my agent, I am in a position to do so. There is also specific direction regarding organ donations, and there is the requisite HIPAA disclosure as well. A couple other things to be aware of here. When this is signed, it needs to be either witnessed by two individuals or notarized. And the instructions on what to do with the document and some other key things are included as a part of the document. These address the issues of what is considered healthcare and how does one revoke a healthcare power of attorney. After it is signed, I generally suggest that you keep the originals, that you make copies available to your agents and to your healthcare providers, and then make sure that there is an entry in your cell phone, in that ICE entry in case of emergency, that identifies who the agents are, and some people are even taking pictures of the documents and keeping that on their phone as well. And then when something happens, the procedure is that the agents will be notified and they will present the documents and be in a position to make decisions on your behalf. The next one we want to visit about is the living will. And again, the living will is different from the healthcare power of attorney in that the living will applies only in a very narrow set of circumstances. When you have an incurable or irreversible condition which will cause your death within a relatively short period of time, or a state of permanent unconsciousness from which, to a reasonable degree of medical certainty, there can be no recovery. Now, one of the first things to note is that this is kind of fuzzy language because it's not entirely clear what would constitute any of those conditions. This document too addresses the issue of organ donation. And the response to physicians with respect to living wills is that they are nice to have, but no doctor, no hospital, no nursing home ever wants to have to make a decision with only a living will behind them. It is perhaps in some respects more symbolic than anything else. But one of the things that needs to be remembered is that with language as fuzzy as what we have in this, it is a pretty good way of ensuring that people will not sue the doctor or will not sue the hospital. When it's signed, again, it needs to be either witnessed by two individuals or notarized. And then, again, there are instructions attached to the document as well. The next document is a declaration of the designee for final disposition, and this is based upon the Iowa Final Disposition Act relating to the disposition of your body after your death. It identifies an agent to be responsible for the disposition of your remains and whatever type of ceremonies you wish to have. It identifies several options: a prearranged funeral, a cemetery lot, donation, or organ donation as well. The purpose of this particular document is really twofold. One is to protect those who rely upon the designee for instructions, such as a funeral director, and to two, help avoid conflict within the family by making sure that it's clear who has the authority to make a decision. There are some other documents. The medical directive was popular some 20-25 years ago in an effort to provide very specific guidance in certain situations of what you would want. They have generally fallen somewhat out of favor simply because medical technology is changing so rapidly that what you may have identified 5 years ago is not even relevant today. There is the do not resuscitate order. The thing to remember here is that the DNR applies only while you are in a specific facility and is only for a specific condition. It cannot be a blanket type of DNR. That being said, however, there is what's known as the out-of-hospital DNR, which states that if you are normally in the hospital or nursing home and you are temporarily out of that facility, then they can allow that DNR to continue to exist. For the last 3-4 years, we have had the Iowa Physician Orders for Scope of Treatment, the IPOST. The purpose here is that your medical providers can prepare a separate form that identifies what you want done in certain situations, the scope of treatment, and then that becomes a part of the medical record. Now again, this is a document that you cannot fill out on your own. It can only be filled out and prepared by a medical professional. Main things to remember from this is all of these documents only grant legal authority for someone to make decisions for you. They do not tell anyone how to make a decision on your behalf. So in that regard, my best advice to you, talk to your family about your wishes and make sure they know what you want to have happen.